Welcome to Law Talk Today, a series devoted to bringing you informative and educational programs focused on issues of law, government, and community. Hello, and welcome to LawTalkToday.tv. I'm Dan Agatino, your host. Joining us in studio today is the other host of the program, Mark Gruber, Senior Attorney at Gruber, Colabella, Liuzzo & Williams. Mark, thanks for coming.
Wonderful to be here.
So today we're going to be talking about divorce and custody mediation, and this is an area that you are expert in.
Correct.
The word mediation might be unfamiliar to some of our audience members, so can we just start with a quick definition and then jump into the...
A definition of mediation, it is a process by which a neutral person or persons help facilitate an agreement between two other people. It's voluntary, and it's like a private mediation. Now, there's a little confusion over what mediation, the nomenclature, because when a mediator has special knowledge, such as tax or commercial mediation or family law or divorce, it's what I guess the ancient Romans called it conciliation. So we, just so a little bit of history, we're really conciliation rather than mediation, but everybody calls it mediation. Mm-hmm. We help people make their own agreements.
So is this something that's done in open court where everyone can see, or is it private?
No, one of the benefits of mediation is that it is private. In fact, there's a lot of cases that have to be mediated because in New Jersey we have a case and a bunch of cases which say that in a divorce case, if people are not reporting all of their income and they're evading taxes, if that goes to trial and a judge hears that there's unreported income, the judge has to halt the trial, send the people to the Internal Revenue Service, the Attorney General, and the prosecutor. And they get prosecuted for tax fraud and evasion, and after the government takes all their assets, then they're back in court if there's anything left to argue over. So those cases have to be done out of court, so a judge never hears it. And so the mediation is private, it's confidential.
The mediation, is that done with attorneys or the individuals go in by themselves?
Well, there's a mixed review on that. There are some people that go to mediators without the benefit of an attorney, and I actually prefer that the parties have attorneys. I think it's much better, and the attorneys keep it on the straight and narrow. Because there are some times in mediation when a person is unrepresented, they still feel intimidated. And I won't say it's women all the time, but there's usually one side of one spouse or the other that is afraid to say no, is afraid to stand up and hold their ground. And so in those particular cases, even in mediation, that person can end up with an unfair result. If there's an attorney there making sure that that person's position is being advanced properly, then it's a more balanced end result.
So let's talk about the end result of what the topics are that are covered. Let's start with alimony.
Well, when I do mediations for alimony, that's probably one of the most difficult issues because alimony is not, there's no formula, there's no equation, and it's based on a judge's discretion on a bunch of factors. And so you never know, if you were to litigate, where that would end up, okay? And you never know how much, and you don't know what kind of alimony it's going to be, whether it's what we call permanent alimony, that's until retirement or death. Rehabilitative alimony, that's for a number of years to enable one spouse to get vocational skills. Or the third type is what they call limited duration alimony or term. So when I have people coming in, typical husband and wife, usually one is making a lot more money than the other, or one is a stay-at-home mom or dad, and the other is the breadwinner, and they're splitting up, and sometimes the dependent spouse says, you know what, I don't want alimony. And I look at that person in the mediation, and I say, well, don't you agree that without it, you're not going to be able to maintain yourself and your children in any semblance of a lifestyle that you presently have. And on the other hand, your spouse is going to be right up here. And I say, don't you agree with that? Mm-hmm. And then I look the other side and said, don't you agree with that? And they go, yeah, so I guess we really ought to be talking about alimony. And then we talk about how much and what I like to do. And I want to spend a little bit of time on this because it is the toughest issue to mediate. I have both sides fill out a budget form. It's 2 pages, and it's where every penny is spent. Gifts, coffee in the morning, stopping off at Dunkin' Donuts, stopping off at the 7-Eleven, groceries, clothing, everything. And they each make their budget. And then they come into my office, and we photocopy it, and everybody shares each other's budget, and we go through them and critique each person's budget. So the husband gets to critique the wife's, the wife gets to critique the husband's, and together we go down and we make what would be a reasonable budget that is consistent with what their lifestyle is or will be after the separation. Now that's the starting point. But at least we've agreed on that. Then I look at everybody and say, well, now let's see how much money there is available to fund these budgets. All right? And for example, if one party is not working, I'll say, if you go to court, the judge is going to say to you, you're going to have to work, and if you don't work, the court will impute income, will set an amount of income as though you were working. And don't you think that's fair? And I talk it through with everybody. And by the way, by doing it in this fashion, there's no conflict. We're all sitting in the room trying to solve the problem together, as opposed to putting on battle and going into court. So we're having intellectual discussions on how much one person should work. And suppose that person is not working, how much they should earn. If they're not working, I'll say, you know what, you need to go out and test the markets. If you're going to want to go back to school, find out where, how long, how much you're going to earn at the end, because we need to get a number for you on how much you're capable of earning, and that's going to go into the mix. Then I look at the other spouse, and I'll say, I need to know what your income is. So they give us information, pay stubs, pay statements, tax returns, and all that, and it's all shared, it's all in the open. And so now I know how much money this spouse is going to earn, how much money this spouse is earning, we know what their budgets are, and then we do the math. And we say, you know what, you've got a surplus of X amount of dollars, and guess what? You have a deficit of X amount of dollars. And I say to them, well, how do you think this ought to go? And they, it takes them a second to realize, well, I guess I have to pay alimony. This is a guy or a gal that came in and said, I don't want to pay any alimony.
Right.
But we've gone through all this analysis and mediation, and they understand the logic. All right?
But the way you're presenting it, it seems like it's very respectful and cordial, and,
right.
And usually there's high emotion in this.
Well, that's why mediation is really the alternative dispute mechanism du jour, because it really is non-confrontational, it's voluntary, and like I said before, I approach it as solving their mutual problems. Okay?
So you avoid the drama altogether.
Oh, sure.
As an attorney, it's just...
And I mentioned earlier that the conciliation part is, I come to the mediation with an expertise, a knowledge of what would happen if they were to go to court. If they had a mediator that was just say somebody who didn't have